Hi, everyone, and welcome to the January 2021 HomeQuest and Gardner webinar. So here at HomeQuest and Gardner, we're a law firm of dedicated, successful, and effective attorneys focused on our clients' needs. We are results-based, providing ethical professional counsel and representation of our clients in the practice areas of litigation, business, employment, real estate, and construction. HomeQuest and Gardner is a law firm of experienced professionals focused on providing cost-effective legal counsel in a timely manner. Founded in 2008, our deep experience in litigation, real estate transactions, business, construction, and employment matters enable our attorneys to provide you with a comprehensive quality representation. Here at HomeQuest and Gardner, we value every client relationship. Your every matter or issue is received the utmost attention. We recognize that your time is important and responsiveness is critical. We act accordingly. We respond to your legal needs promptly, not days later. So thank you for joining us today for our webinar on pre-construction best practices and lien overview. Presenting today for the first time as a partner at this firm is Rob Maxwell, so congratulations to him. Rob joined the firm in 2015 as an associate and has been working hard here ever since. During this webinar, Rob is going to take a look at some of the best practices for contractors and owners prior to projects, as well as a general overview of lien disputes. After all of this, we'll take some time for a Q&A with him. During the webinar, feel free to send us over your questions using the question feature, and we will either have those answered in real time or save them for the Q&A. All of these questions will be saved, so if we don't get around to answering them during the webinar, we will try our best to reach out to you post-webinar. All right, Rob, thank you.
All right, hello everyone. Thank you first and foremost to Mike and Jackie for kind of being the back end on all this and helping out. We really appreciate it. And it's been one of these new things that we're working with COVID and getting as much resources out to our clients, to the general public, and seeing these. So I know we've looked forward to doing these webinars, and we've gotten some great feedback. And actually this webinar specifically was based on feedback from our last webinar in December of some of the issues that our clients and people wanted to hear about. And what resonated a lot with them was construction disputes and looking at some of the items that go into the totality of those issues that come through our office. The jumping place for me on that is obviously from the start. And when we're looking at this, and today I wanted to take the time to go over some pre-construction practices, and I want to make this as practical of an approach as possible. I don't want to go too deep into the weeds, but I do want to reiterate that I welcome questions and we'll try to answer them in real time. I know that's kind of difficult in this virtual setting, but I want this to be as interactive as possible so that everyone here, if they have something specific they're looking at or something that they want to spend more time on, I'd love that feedback in real time so that we can address that and make this the most productive for everyone. Right, as Jackie was saying, we're looking at this from the perspective of both contractors and owners that are getting into, mainly we're going to focus on residential real estate, but it has application in the commercial setting as well. But the biggest and first place we start on all this is pre-construction. What's happening when you're jumping into a project, whether it's you're looking at the reality of a full new home build, whether you're looking at remodeling, some smaller electrical work, all the things that go into that. What are some of the best practices we can see to avoid litigation, which is the biggest thing. No one wins once it gets down that route. So if you get into a situation early on where you're trying to compensate and know your risks going into it, make your contract clear and concise so that everybody understands the process that they're going into, everyone's going to be set in a better path forward. Sadly, a lot of the issues that we see come through when the pre-construction really hasn't been gone through all the way. But we want to look at that from the perspective of, okay, hey, what can we do to avoid that issue from the outset? And the biggest thing here is from the start, getting a clear and concise contract ready. I can't tell you how many times we get an issue that comes through the door, and one, there's either no contract, two, there's a contract that really nobody read or looked at prior to entering into it, and it has a bunch of terms that are inapplicable to the scope of the project. They're hazardous to the owner, they're hazardous to the contractor. And once it gets down to the nitty-gritty, people are trying to figure out, how do I compensate for this? How do I make it right? And that's where litigation comes in. And once you go down that road, a lot of the times it's a no-win. It's everyone loses in that battle. So from the get-go, I want to start here first from the contractor's perspective. And as we were just discussing, the critical phase and the critical part of this entire thing is the contract. Getting that, let's stop and think about all the options we have here. First and foremost is there are so many contracts we see just from somebody jumping online, typing in construction contract, getting it and thinking, okay, hey, this is great. This talks about Washington. This will be fine. I just want to get this contract under. I want to get this owner's begging me to do the work. I want to start and get going. Using one of those boilerplate or contracts that really are inapplicable to the current situation that you're getting into is just, if anything goes wrong, it's just going to set you up for a very complicated litigation matter. So you really want to take the step back from those and say, okay, what do I need? What is this client and who is this client? What's the scope of the project? Do I know that I can do the scope of this project? Am I clear on my estimates? Am I clear on my time frame? All these issues kind of get scraped by when people are moving fast. They say, hey, this project looks great, met them really quick, and I think this is roughly what the estimate is going to be. And so they jump on it. And that kind of bypasses the whole process that we looked on there of really narrowing down the contract, getting the scope together, looking at the designs and everything that goes into it. You'll see a lot of it in our practice where people come through and the contract mentions a specific design or drawings and that are attached to the contract, and those don't exist. And so it's just a useless term once it's in the contract like that. You want to take a step back and say, what's the land we're looking at? What's the property? What's the state of the permits? In some places, King County, Seattle, getting the permit in and of itself is a monstrous delay. It's the time that goes into it right now needs to be considered in the overall project, obviously, but that's a big part of the planning. Engineering, and then the big part from our perspective is knowing your risk, having a clear remedies provision if something does go wrong. And we'll get into it further in this, but talking about approach of ADR in the pre-contracting stages so that everybody's clear on what will happen should something go wrong. Mike, if you can go to the next slide there. Okay, so getting into the residential construction mindset, there's a lot of resources here in Washington that are actually great. And I want to first and foremost give a kind of a plug for the Washington State Bar construction section, because it is a great resource for contractors and for owners to look through and see some of their examples and their contracts that are made specific for Washington. Specifically, they have on their website, if you are able to go to it, they have a fixed price lump sum contract there, a cost plus contract that can be great jumping points. Now, that's not going to be the win all for every situation, just as we talked about, but it's a jumping point to one, look at a contract that's been vetted by the attorneys in Washington State and is actually published by the construction section. So you can get an idea of what terms are out there, what they're looking at, some better practices, what can come with that. And so that is a great and free resource that I would suggest everyone, I put a link up there on the slide to it, to take a look at, just to get an idea of what's out there from an attorney perspective and from also an owner perspective. And I'm going to stop really quick because I did get a good question already of what's ADR, and I just want to answer that in real time. That's a term for alternative dispute resolution. And so when we're talking about that term ADR, that's what I use that for, is essentially avoiding formal litigation in the court. So ADR can mean mediation, it can mean arbitration. but it's just outside of the general formal litigation, say in King County Superior Court. You can have remedies to try to get through the process through an agreed upon mediation structure or arbitration. So I wanted to stop there, and that was a great question, and I'm sorry I abbreviated that, and so we'll keep pressing forward here on the Washington State Bar construction section. So again, that is an absolutely phenomenal resource for the community and for attorneys. And so if people get the chance to go look at that, that'd be great to run through and get a jumping point for contracts on that. Mike, if you can go ahead to the next slide. So one of the contracts that I just mentioned is this cost plus contract. And generally speaking, the cost plus contract is one of the most used ones you see in the residential setting. And it's basically been generally described, you can see up there, but we're talking about an estimate on it, and the contractor is taking a percentage over that to cover their actual costs and the spends and labor and materials. So it's not what you would consider a fixed price. You're not going into it saying, hey, here's my bid for $10,000. This is the absolute, it's going to go. It's more akin to setting it up so the owner and the contractor know generally what the costs are, and it's based on estimates and good faith estimates on what's going to come. But it's also a way of stating that there are going to be unforeseen situations. And so that actual cost is going to be the determinant factor on the contract. Now, these are great contracts from a contractor's perspective, because obviously you're not putting yourself against a wall for a fixed price going into it. But during that process, it's also can lead down a very scary path with an owner that doesn't get a good and clear message on the scope, on the control estimates, the timelines of the project allowances. And this is one of the most litigated issues, but changes to the scope and the contract in general. So if you're going through the project and something pops up that was unforeseen, how is that handled? When you have these cost plus contracts, one of the critical aspects for me that I want to see from every contractor out there is don't delay on putting out change orders. Make change orders a part of your contract. Make it a ready practice that if you encounter something, there's a notification of the owner that, hey, this is off from the estimate right away. And that if we're going to proceed on this work, these are going to be the change costs. And that actually could be a reduction in cost. It could be an increase in cost, but we want to have those in writing. We want to have it in front of the owner to make sure that they understand that that has changed, that the contract is coming up on something that wasn't accounted for. These issues that come up, you see it time and time again, is people get into the contract, they have a change order provision, and no one uses it. It's word of mouth. We talked to the project manager on site. He said this was going to change. We said, hey, that's great. We didn't talk about price. All of a sudden, we get this major bill for a change of a placement of a window that we didn't expect. And then you start down the process of the owner is now looking at every issue, every fine tooth comb in the project. It just turns into kind of a poisonous environment within those residential contracts. So the change order provision is critical from both the owner and the contractor side. And it's one of those that just should be harped on, that you don't want to skip on that. You want to make that clear from the outgo that, hey, here's our scope, and you want that scope as detailed as possible. You want drawings, you want renderings, you want everything that's possible to be attached, so that as a contractor, if you do encounter a situation that's not within what you believe is the scope of the contract, you can easily take that to the owner and communicate it, get the written change order together, have that in the pile of everything that's going into the whole construction, so that if anything comes back, you have that to rely on if costs override in the future. And that gets back to the estimates, and touching on that from both the owner and the contractor's perspective. Estimates in the world of construction, it is what it is, right? To hold and to go into a contract thinking on a residential side that it's going to be exactly what that contractor estimated is a very, very bad mindset to get into. You always want to leave a little bit of wiggle room for the change orders that come in. A lot of people will use the practice of having allowances. So, hey, here's a contract amount. We think it's going to be about here, but we'll allow it to go up a little bit. And we can vary that and see what's going on with it. And so we can monitor the project as it's going, see the allowance. We can have a spreadsheet that's set up for, and this is a best practice that I see a lot as well in these contractors that are successful in disputes, is they have a spreadsheet of their timeline. They have the hours worked of their employees. They have everything down to the day on scope and everything that is going into the project. When you don't have that and an owner complains on the back end about work performed or what was done, and you can't readily back that up, there's this back in the mind thought that they don't have that to support what they're claiming. And so having that just as a baseline for the contractor going through, time and time again, being diligent on the project, updating, making sure your employees are logging their hours or saying what they actually worked on that day, so that you have that progress to go through. And with the cost plus contract as well, if you're doing it on progress payments throughout the process, then you want that as well from an owner's perspective, so that you can see up to that date. Let's say January 25th is the time frame that you're going to submit the bill for January. You want all of your work as a contractor up to that date in there. And as an owner, you want to see that all the work up to that date has been performed, and you want to request a lien waiver for that amount once it's been done to protect yourself on the back end. That's as an owner. And so that's one of the big critical components that I just see time and time again on the litigation side, is people are not following the process to go through, and they wind up with cost overruns that were unanticipated, and sometimes they don't have the money to cover it and pay the contractor. Sometimes they just dispute what the contractor is doing, and that just leads down to a really bad situation. That's especially if it's mid-project. And now you've got this tension between the contractor and the owner. Owner's looking over the contractor's shoulder on everything, and it just doesn't turn into a good situation on the back end. It's just everybody's frustrated with it. So being clear and concise as a contractor, but also having all the information to back it up is the greatest way to go. All right, and Mike, if you can go to the next. And the fixed price contract, these are, there's situations where I see these, and there's situations with specialty contractors that are really honed in. They know exactly what they're doing. It's possibly a similar installation, a similar spec build that they know almost, down to a T what that fixed price of that product is going to be. And those can be used, but it's always going to be a risk to the contractor if anything comes up. Once you've agreed to that fixed price, you're stuck with that unless something is agreeable on a change order or if something comes up. And again, we get into the discussion of those change orders and what work can come. And another point on those fixed price, I had a past case where it was a fixed price contract, and the contractor, realizing there was a fixed price, did not stay up to date on the billing side of things, the employee hours, everything to justify where that came from. And it turned into a big mess in the end when you don't have that information to support once you go into a contractual dispute. So the big part about that with the fixed price is it may seem like, hey, this is an easier way to do it. We don't have to keep track of all this. We know the price. I would still always advise and recommend that a contractor on the back end take the time to still essentially go through the same process that you're doing on a cost plus contract, keeping track of everything to the T, making sure you have all the hours logged, everything going into it. One, from your own business side, you can see exactly how profitable something was based on the hours and effort used. But also on the other side of it, if someone's complaining that work wasn't done or something wasn't done correctly, you can look back to that and say, no, this was done at this time. This is signed off on this this inspection. And so it's a good process to get into as a contractor. Mike, if you can go ahead and change the next one. So we touched on this a bit, but there at the top, this is, I want to go through some of the key contractual protection clauses that I see out there for contractors. And touching on the question earlier with ADR, this is a way to ensure that everybody out there understands and has a way to, one, to account for what is going to happen if there is a dispute, and two, to avoid the extremely costly process of going through what, a formal court setting and the time that goes into that. I mean, if you think about it from Seattle here in King County, once you get on that litigation schedule, they set your trial out a year. And so unless you have some good argument on summary judgment or something that's clearly going to be solved before, if it goes down that whole route, at a minimum, you're looking at that trial date out in a year. Okay, I'm going to pause here for a moment and go over, there was another question that was posed. And the question is, are there common issues around scope being well-defined or not on fixed price contracts? Yes, that is another one it's a great question, because it's something that you want to go through on the scope as well. I mean, yes, understandably on a fixed price contract, if you say you're going to install or do electrical on the house, there's that general understanding of where it is. For some of those specialty contractors, say plumbing, you're going through it that route. But on a fixed price contract is just as valuable to put in the scope of what it's going to be. And that way, if there ever becomes a concern with what was provided for in that fixed price, you can always turn back to it and say, no, this is the scope that we agreed to. This is the scope that we got into. And you can justify that to the owner and say, okay, here's exactly the plans or the drawings. Here was the cost of that. You are now asking for something outside of what that is, and that should be done via a change order, and that's above and beyond the fixed price. So yes, it's just as important. And all of these, scope actually is probably, I'm going to put it up there as one of the highest thresholds that you should have completely covered before jumping into a project. That's going to avoid a lot of the dispute, and it's also going to protect the contractor on the back end. So thank you for that question. And the other ones that I want to go through on this kind of the ADR process that we're looking at, part of this is a lot of these can be solved through something short of a formal litigation setting. And I do utilize arbitration clauses. I do try to utilize as much as possible mandatory mediation. And that's just because in the construction setting, you become a sounding wall for yourself if you're frustrated with something. Having somebody step in as a mediator and seeing if they can resolve it, looking at it from an outsider's perspective, is not only cathartic, it can resolve the problems short of full-on litigation. And so I always value that. There's some people that don't want to go through the process of mediation, but from a construction standpoint, I think exhausting that route to me is a no-brainer in terms of effectiveness and then cost savings in the long run. And then after that, proceeding down the arbitration path, or looking at if you have to go down the litigation path, obviously that in and of itself is an option on remedies, but I do like to have that, and I value the arbitration mediation path before there. So on there, you see some of the other ones, some of these protections and clauses to think about as a contractor. Some of the big ones, time limitations on suits, time limitations on how long an arbitration hearing can be. And you have to remember that once you're in arbitration, you're paying the cost of the arbitrator, okay? So that's something you've got to consider in that whole process. But if you look at it from the perspective of what can be efficient, you can put time limitations on how much time that arbitrator is going to take, how long the hearing is going to be. And that can be beneficial for both parties involved, obviously, but it also just creates an expedited time frame where people have got to be ready. You've got to put your best foot forward. You have to have your case ready. And you know that the cost savings on the arbitrator side just means you've got to be the most prepared person going into it. And that comes with having done all the legwork early on from a contractor of having everything, all of your time slips, having all of your estimates, having your drawings, having your daily log all set up. Now the other option that I always value from a contractor's perspective, because it keeps it in their control, is a mandatory repair option, meaning that if an owner does have a dispute prior to filing in it, they will notify you, and they will go through the process to work with you to give you the first option of repair, or possibly pay the reasonable amount for what that would cost for a third party to do it. And that just gives you a little more control as a contractor. The other option there that I list, it's incredibly valuable for smaller ones, small claims court. So having a provision in there that if it's under a set of the small claims threshold, if it's under $10,000, that it has to be filed in small claims. It avoids attorneys and avoids cost. Okay, Mike, if you want to go ahead into the next slide. Okay, so this is one, and this is just like probably one of the bigger ones that we see time and time again when it comes down to contractor protections, is your disclosure statement required by law for liens going into it. And we'll get into the liens in a bit, but I just want to go through this and just make it a practice point as a contractor that put it in your contract. And this is codified, so it's RCW 18.27.114. So anyone can look at it, and there's no need to reinvent the wheel. You take that, copy paste, put that as an addendum to your contract, have the owner sign off on it, so you're not thinking about it down the road. Too many times I've seen it as a defense when we're going through the contract that the disclosure statement wasn't provided, and rather than even having to go through the ins and outs of when it should be required and when it shouldn't, just make it a practice point to put it within your contract. All right, next slide there, Mike. All right, and we touched on this briefly, but this is another one from the contractor side that protects you and protects the owners. And there's a lot of case law that has been very, it's not very forgiving for contractors. And there's the Mike M. Johnson case out there that if you're not following the notice provisions of your own contract, that can be seen as just an automatic waiver of your right to assert some of the claims. So where that comes into play is you'll see the contracts that say all extra work will be performed by a written change order. And the written change order in and of itself, when you have that language there and then you're going back and forth and saying, well, no, you told me this. We talked about this on the project one day. You're opening the door for litigation on that. So what you want to do is, again, everything just in writing on a change order. And if you're going through that and you have a notice provision within there, double check your contract, see what it actually says, and make sure you're following that protocol. All right, and I had one more question up here that I want to get to real quick. Are there differences between arbitration versus mediation? Yes. So when I'm talking about mediation in general, we're talking about a voluntary process that both parties agree to meet, to have a third party look over and review and kind of give them a third party opinion to try to get them to meet in the middle to find an agreeable settlement. It's voluntary, nothing's mandatory at mediation. Now, arbitration on the other side of the coin is a more formal process. It's I can kind of describe it as litigation light, right? You're following some of the same procedures as you would in a formal litigated matter within the court, but you are paying for a private arbitrator and you have set rules of how that arbitration is governed. But that arbitration can run through the process and they have the ability to, to make evidentiary rulings, to have hearings, to go through the entire process similar to a formal litigated matter in the court system, and to ultimately decide who's right or wrong. So if you want to think of it from a perspective is, arbitration, yes, it's the mandatory process and the push. And it akin to litigation, whereas mediation is more, hey, can we resolve this? Let's look at all the options here. What's in the best interest of everybody, and push forward. Okay, Mike, if you want to go ahead and change the next slide. Okay, this is another one that I want to touch on with the contractors here. The correction of work provisions within your contract. At the end of a lot of contracts, ultimately it comes down to when they're doing the last inspection or the punch list, those items can get drawn out and drawn out and drawn out. You'll see some owners come through with this comprehensive punch list, basically saying that everything under the sun that you've done is wrong, and expecting either a discount or you to work or correct those items. So the big part about this for me is making it concise. One, define your scope. The scope's early on, so you know what would be within a punch list item or not. And make it within your contract to have a single punch list, a single inspection at the end. I've seen some contractors utilize a progression of punch list. So say you have a milestone, the framing or whatever is coming up on the project, maybe foundation work, that the owner has an option, 5 days after that has been completed or whatever it may be, that they have an option to come out, inspect, bring their own inspector out to see, and then sign off so it progresses, right? And so that's an option, but that's a time consuming and it can delay issues on the project if you're trying to keep things going and you're waiting on the owner to come through with his inspector, or if the inspector comes through and says, no, this needs to be changed. So it's kind of a double-edged sword there, but ultimately you want to have control over how far those punch lists and the correctional work can go. Now, I've already stated that you want to keep the control of the repair in you, and that's a great thing from a contractor's perspective. But yes, keeping it concise to a single punch list. I've seen over and over again where a punch list goes and then the punch list goes to another punch list and it keeps doing down the line, and the contractor's going, oh man, I'm losing money now. I'm just spending time on this project and nothing's getting completed. And then the other aspect of this from the protection side is also if they're not notifying of an issue, that goes into the timeframes of the contract. So if it's not brought within the punch list time period, then it automatically goes over to either a warranty or within the contract side of things. And so it's a different method for dealing with it. All right, Mike, if you can go on to the next one. This is one that I haven't seen too often, but it's one that has caught a couple of people off guard, and that's not accounting for sales tax within the contract. Okay, so in Washington, if the contract does not state whether the price includes sales tax, the presumption is the owner must pay the contract price plus sales tax. Okay, so that can catch quite a few people, owners and contractors, off guard. So just make sure you're aware of that. It's clearly pointed out as a contractor, the plus the sales price as an owner. If that's specifically negotiated as it's supposed to be included, make that known. All right, Mike, if you can go to the next one. The other one to really look at is your warranty clauses as a contractor. Obviously, you want to get the work. You want to get the work. You want to get the bid in. You want to continue to operate as a business. So you've got to have clients out there. So you can't have this ridiculous warranty that basically disclaims everything that you're doing. It's got to be fair and equitable. And you can approach that from the same perspective as any of those other contractual clauses that we're talking about, with time limitations, right? When the claim must be asserted, how long that goes. A lot of contracts will say that the warranty period, just generally is a year from substantial completion. Well, that always brings up the problem of what was substantial completion if you don't have that specifically called out and agreed to within the contract. So some of them that I've seen that work, and I haven't seen this actually go through the court system, but it's an interesting contractual provision, is setting the warranty date for just a set month, from the project starts. So say you've got a project that is estimated for 6 months, and saying the warranty will go for 18 months from the contract date. So there's interesting options there, and at least provides the clarity there. But again, generally speaking, a lot of the times you see it from the substantial completion date. And I'm going to pause here for a moment. And I want to go in through just kind of a practical thing on the pre-construction, also for owners, and just some things I've seen in practice that owners get caught off guard. And this is particular to Seattle, where we have a lot of older homes. I've seen a few times now where a project has been completely, essentially shut down or dismantled by L&I due to asbestos related issues. So if you are a contractor and you're getting into a project, and this goes from any project for any older house, you've got to go through the process of doing a good faith study if there's asbestos, and making sure that that's done and concluded prior to opening up walls, prior to starting the construction. And if it does catch up to you, or if God forbid you get an employee complaint directly to L&I and they visit the site and asbestos is found, it not only opens up the doors for stopping the whole project, but there are some very serious fines that are associated with it. So just keep that in mind when you're looking at it from a practice point. For older houses, the cost up front for getting an estimate and getting a asbestos inspection out there to see if maybe there's some that should be a concern, and having that remediated is much less, and you can approach that with the owner, is much less than seeing that a project completely stop and L&I come out and start asserting fines against the contractor for not taking the right protocols. Okay, and I'm going to stop here for a moment, and there's another question here. The question posed is, if the owner is a general contractor and they have a resale certificate, do they still have to pay sales tax? So I'm going to stop there, and I guess the question is it posed as a sales tax for the project? And that's the sales tax that I'm talking about, the overall sales tax associated with the total cost of the project. If you're talking about a resale certificate, if you're talking about a condominium being sold, and the taxes that are associated with that, you might be referring to the real estate excise tax, which is a different thing for the transfer of the property. But generally speaking, as a general contractor, if it's not in the contract and it's not specifically done, the presumption is that the owner is going to pay the sales tax, but you just want that clear. You want it very clear to the owner that that sales tax is in addition to the contract total. Okay, and Mike, if you can go ahead to the next slide. So we've focused a lot on the contractor side, and I know we're pushing up on some time, but I did want to briefly touch very quickly on the owner and due diligence on this, and just some of the resources that are out there. I've actually seen multiple times people come in with contractor issues, and the first thing I do is I look up the records on L&I and see, what's going on with the contractor. Are they new? Have they been around for a while? Is everything up to date on their registration? And I've seen a number of times that the contractor is in litigation based on the L&I records at the time that they entered into the contract with the new owner. So from an owner perspective, it's a very easy resource to just go onto the Washington State L&I website, put in the contractor's name and just see the background. A lot of the times there's very new contractors that pop up. You always want to give somebody the benefit of the doubt, but you always want to think at the same time is, how much experience does this individual have in comparison to where my project's at or what I need, and if that's going to be the best fit for you. And then the other thing that's going to come up, are they bonded? Are they registered? Do they have insurance in place? All the things that are critical to jumping in with a contractor are contained on that L&I page. The other one that can just kill a project is not doing the due diligence on, if you have a homeowners association affiliated, if there's an architecture committee, that's out there that you need to get approval for the construction prior to going in. Neighbors are can be the biggest hassle on any construction. You will see it time and time again that a disgruntled neighbor will continually reach out to code enforcement. They'll continually reach out to whoever they can to try to disrupt the project because they don't like what's going on. And you hate to see it, but it happens. So as an owner, it's always just a neighborly thing to touch base with your neighbors, let them know that a project's going to happen, and see if you can gauge that, if there's going to be any real big pushback. So you at least can know, even if the project's going ahead regardless, you can know what you're going to deal with. And then the past projects of a contractor is a big one. Getting that information on, if they have a portfolio or pamphlet for their past projects is huge. Okay, Mike, if you can go on to the next one. And then again, I can't harp on it enough that as an owner, don't just take the contract that you provided and say, okay, hey, he's gonna do the work. You need to have those protections in there. You need to understand what the contractor's doing. I always want an owner to have as much information as they can and be the ability to get that information as the project is progressing. So make sure that's a part of your contract. If there are terms in the contract, as I said before, that says the scope is based on these drawings or these architectural renderings, make sure that is a part of the contract. Don't just have that term in there and never provide those. It's sadly, I see that far too often. Okay, Mike, if you can go on to the next one. And again, this is pointing to what we're talking about in the overall process, but keeping track, don't rely on your contractor to fully keep track of all the project milestones. You don't have to pester. This is not me saying to an owner, you need to look over the contractor's shoulder at everything, but know that you have that choice to audit the records to understand what the costs are and what's going forward. And the next slide here, I want to get into it because I know we're pushing up on time here. I want to generally go over kind of the lien process in Washington and what that entails from both the contract. Go ahead and go one forward, Mike. Thank you. And so you've probably heard the process at some point in your life, but contractors, they have the right to lien a piece of real property based on the work and their circumstances where subcontractors come out of the blue, contractors on non-payment, but they have this right that's codified in Washington for a mechanics lien. And when you're looking at the mechanics lien process as a contractor, one, you want to make sure that all your records are straight, that you understand that process getting into it, and you've provided the proper pre-lien notice. So Mike, you can go to the next slide. So understanding, just as a baseline as a contractor and an owner going into the project, is what are the pre-lien notices? Who gets it? When should it be provided? Where does it have to be sent? And on the back end, what happens if you don't do it? So Mike, if you can go to the next slide. So one of the big ones on the lien side of things is the notice to owner, and that's codified there. You'll see it RCW 60-04031. And this is primarily it's used by the subcontractors on a project, but you want to make sure that anytime you're performing this work as a subcontractor that you know of this, that you're getting this out the door and you're providing it to the owner and you have a record of that being provided. Because in the end, that's going to be the biggest hindrance to a mechanics lien if you don't get paid by the general contractor. So the lien in and of itself, it allows that subcontractor, even though they may not be in direct contract with the owner, through the work that they provided, they have the ability to leverage non-payment against a third party, here being the owner and their property. And so if you lose that as a subcontractor, you're at the mercy of the contractor. And you just don't want to be in that position. And it's a very simple and easy thing to do. Just put it on your schedule. Your first day, you're sending out the notice to owner. And then the next slide there. The next one is, and there's two different ones here, and so people often confuse these, but the other one is for when the generally a general contractor is in contract with the owner, and that's the notice to customer, and that's codified, and that's what we spoke about in the early on within your contract. Just make this a part of your contract to provide to the owner. Without these pre-lien notices, it can be a big defense to any lien, and it just makes a lien process to foreclose on one very difficult and a hindrance rather than straightforward. It's supposed to be there to provide a contractor the leverage to get paid for services provided that are affiliated with real property. Okay, so next slide, Mike. Okay, so the other process that we just need to be aware of the timeframes, and these are critical. Anytime you're in the process of not getting paid and you're looking at the process of having to file a lien, you want to make sure that you're diligent about what your last day of work was. You know, when on the time frame, putting that in your calendar and getting much further ahead on that than need be. You do have a 90-day period in which to record and send notice of it from the last day of work. If you're getting the hint that nothing's going to go through and you're not getting paid, what's the harm in doing it earlier? I would rather be ahead of that time frame than expose any argument that we're pushing up on the 90 days. And remember that after that is done, especially as a subcontractor, you've got to mail that to the owner and have record of that by certified or registered mail, or you can personally serve, but that protects the attorney fees and cost against the owner. So make sure you're utilizing that so that it's not just a effort to get the contract sum, but you can also get the amounts that it's taking you to go forward with it. All right, and the next slide is the end result of if nothing gets resolved after filing it. You have to be critical and you have to file the case to foreclose on your lien within 8 months after filing the lien. And I've seen this time and time again, that you'll get a lien that pops up and it just doesn't go anywhere. And you still see them all the time. They'll pop up on your title and it's been longer than 8 months. And the nice part about that is most title companies readily see that, they understand the law, and they can remove that from title without a lot of issue. But as a contractor, if you don't move forward with filing that, it's just evaporated. You lose that lien right. Okay, Mike, and that's it. I know we're pushing up against a time frame, so I did want to sit here for a moment, and if there's any pending questions, I don't know if we have the capability to open it up for oral questions rather than writing. Mike, do we have that ability? Okay, so it's all based on the writing. So if you've got questions here, okay, perfect. So we just had one pop up covering lien releases. So lien releases going through the process. So we can kind of, I want to categorize this into two. So we have lien releases that I see as a progress going through. So you pay a contractor or a subcontractor a certain amount as an owner. What you want on the back end of that is for every amount that you've paid, you want a full lien release up to that date. So the work performed through January 25th is paid for, and all work prior to January 25th is part of the lien release. And the contractor saying, in return for accepting this payment, I'm waiving all my rights to a lien up to this date. So that's a very good part of the process. And then at the end of the project, you've got all those lined up, and then you can have the last big part, which is just the full lien release and waiver on final payment. And so that's a critical component of going through the process, and if possible, contract dependent. I love to see those with the progress payment, that every single progress payment comes with a lien release for not only the contractor, but the subcontractors, ensuring that nothing is popping up on the back end. So another great question here is an individual starting a new build as an owner? And is there a contract vehicle you'd recommend from the owner point of view and to provide the best mutual outcome? So this is actually a great resource, again, pointing back to the Washington State Bar Association construction section on their website. That is a very fair and equitable contract. So looking at that as a basis, as like a jumping point, if you wanted to understand provisions or see how those provisions are set up, I would look through both the fixed price, so you understand that, and the cost plus contracts. Depending on the contractor, obviously, if you're an owner going into a new construction build, that owner is going to come out, or that contractor is going to come out, and most of the times they'll have a bid, an estimate, and then it'll be formalized into a formal contract that they've already had vetted, they use. But that doesn't mean you can't push back and negotiate terms that you want to see in there. So always take that time. Don't just, I mean, the worst they can say is no, right? And so always, if you're looking for somebody and you like them and you want to move forward, don't be afraid to ask, because that just establishes the parameters going into the relationship. Okay, and so that's all for the timeframes that we have today. I'm right up, you'll see on this slide is my contact information here. I'm available for any of the questions that come up on here. And if, this is a very high level review of everything that's going on. I hope it was informative, but I really want to go through the process of, if you want to get into the weeds on something, or you have to have a specific follow-up question, please reach out. Don't be afraid. Reach out to my email. We can set up a call, or we can just go through the questions that you have so that I can, best answer anything that came up from here. But again, I thank everybody for the time today. If there's anything else, let me know. And I hope you guys all have a great Friday and weekend. Thank you.